Hello and welcome to In Depth. I'm Teena Jha. The Supreme Court on Monday adjourned its hearing on a fresh petition challenging the constitutional validity of Article 35A, the provision that empowers the Jammu and Kashmir Assembly to define who are its permanent residents and what are their special rights and privileges. Article 35A has been challenged on grounds that it was not brought through constitutional amendment as required under Article 368. Petitioners contend that it is arbitrary and contrary to fundamental rights like the right to equality, dignity of women, freedom of speech and expression, and the right to life and personal liberty. The issue has triggered widespread protests in Jammu and Kashmir, in which several people have been injured. A political debate is also raging, with political parties presenting their views and counter-views. Today in Depth, let's discuss in detail what Article 35A is. What are the special privileges that it bestows on the citizens of Jammu and Kashmir? Under what circumstances was it incorporated in the Indian Constitution? And what is the current controversy? After partition, millions of people were displaced in India. They settled in various parts of India, and over time, they became an integral part of the society. These people were called permanent residents of those areas. But the situation was different in Jammu and Kashmir, where even today, the fourth and fifth generations of people settled decades ago are deprived of their rights under Article 35A. Let's understand this in detail.
Under Article 35A of the Constitution, permanent residents of Jammu and Kashmir have some special rights. Article 35A gives the Jammu and Kashmir Assembly the right to decide the definition of permanent residents of the state and prevent the people of the other states from buying real estate in Jammu and Kashmir. This has meant that many people who have come from outside and are living in the state for the last several decades have not got any right in the state. Hindu families who migrated from Western Pakistan in 1947 and settled in Jammu and Kashmir are refugees till date. According to data, in 1947, 5,764 families had settled in Jammu. These families have not got any civil rights till now. These people can't get government jobs. Neither can their children enroll in government institutions offering vocational education. This situation is not just limited to the people who came and settled from Western Pakistan, but also many others who settled here after independence from other parts of the country. These include people from the Gorkha and Valmiki community. In 1957, about 200 families of the Valmiki community were brought from Pakistan to Jammu and Kashmir. But according to a cabinet decision, they were brought here specially as cleaning workers. For the past 71 years, these people are employed in cleaning work, but they are still not considered permanent residents of Jammu and Kashmir. Even today, these people don't have the right to vote in the state elections.
Well, I told you that it was implemented in 1954, or rather it was inserted as a presidential order in 1954. Essentially, the question was that at that time, the move was to extend Indian citizenship to the people of Jammu and Kashmir. Jammu and Kashmir was the only state which had a State Subject Act which guaranteed property rights to the citizens of Jammu and Kashmir. So when the question of implementation of Indian citizenship or extending Indian citizenship to residents of Jammu and Kashmir came, so the idea was how to protect the State Subject Act, which gave exclusive property rights to citizens of that state. The protection was necessary because at that time, Jammu Kashmir was the only state which had this kind of act. So it was felt that property should not be owned. By extending Indian citizenship, property rights could not be transferred to rest of the people from the rest of the country. So it was basically to protect this exclusive right which citizens of J&K have. Therefore, Article 35A was inserted through a presidential order to protect State Subject Act of Jammu and Kashmir.
According to the Jammu and Kashmir Constitution, a permanent resident of the state is defined as a person who was a state subject on 14th May 1954 or who has been residing in the state for a period of 10 years and has lawfully acquired immovable property in the state or migrated from the state after March 1, 1947 and has gone within the present Pakistani border area but has come back with a resettlement permit in the state. Under this, citizens of any other state can neither buy property in Jammu and Kashmir nor can they become permanent resident of the state. Simultaneously, according to the notice issued by then Maharaja Hari Singh of Jammu and Kashmir in 1927 and 1932, the permanent citizen of Jammu and Kashmir can be the same person who was born in Jammu and Kashmir in 1911 or before that and has been living there since then, and also the ones who have legally purchased property in the state.
When a woman from Jammu and Kashmir, a citizen of Jammu and Kashmir, or a state subject in this case, marries an outsider, she loses her right to ownership of property. This was the case. But an amendment, or rather, there was a major court case in 2002 which transferred citizenship rights or right to own property to a woman who married outside, but did not allow the woman to extend this right of ownership to her children, which doesn't apply to a man. A man, if he marries an outsider, both his wife and children get state subject certificates, which enables them to own property and get all the rights of a state subject. But that doesn't apply to the husband of a woman from Jammu and Kashmir or the children. So that is the gender question about this State Subject Act. Secondly, apart from, I think, also another major violation of human rights, if you look at it that way, is the manner in which this State Subject Act treats Dalits. Balmikis were brought in 1957 from Punjab to clean the filth of Jammu, and they were given conditional state subject rights. The condition attached was that while they can own property, but they cannot work at any other job except being Safai Karamcharis. So the children of Balmikis are condemned to just be Safai Karamcharis in the state. I think this is gross human rights violation. And the third is the status of people who came from West Pakistan, who came in 1947. These people have Indian citizenship, but they're not given state subject rights. So that is the other major concern. And all these three are matters which the Supreme Court is hearing.
According to Article 35A, a person outside Jammu and Kashmir cannot buy any immovable property in the state. Also, a person from other state cannot become a citizen of Jammu and Kashmir. Article 35A states that if a girl from Jammu and Kashmir marries an outsider, then she will lose all her rights. However, in 2002, the Jammu and Kashmir High Court issued an order saying in such cases, a girl's right will continue for life. Under Article 35A, refugees from Western Pakistan are still deprived of the fundamental rights and identity in the state. People living in Jammu and Kashmir who don't have a permanent residence certificate can vote in the Lok Sabha elections, but can't vote in local bodies and assembly elections.
If a Jammu and Kashmir girl marries a person from another state, then her rights and rights of her husband should be the same as the rights of persons involved in another marriage. That is, if a boy of Jammu and Kashmir marries a girl from another state. As it is, there is a difference in the rights of a male who marries a girl from another state in India and the rights of a female who marries a boy from another state.
In fact, Article 35 gives special powers to Jammu and Kashmir as a state. It implies that the state government has the right under this article to give and abstain privileges to people who migrated there during independence and other Indian nationals in Jammu and Kashmir. Bureau Report, Rajya Sabha TV.
Article 35A does not form part of the 395 articles of the Indian Constitution. It is in fact found in one of the appendices of the Constitution. It was inserted through a presidential order in 1954. In recent years, the constitutional provision has raked up an intense debate. In our next report, let's take a look at the history of Article 35A. Before independence, Jammu and Kashmir was a princely state. Maharaja Hari Singh was the ruler, and the citizens were referred to as subjects of that state. In 1927, Maharaja Hari Singh passed the Hereditary State Subject Order that defined state subjects and their rights. It granted residents the right to government office and the right to land use and ownership. These rights were extended solely to state subjects and eliminated any availability to non-state subjects. It also regulated migrants coming into the state. Even after the accession of Jammu and Kashmir to the Indian Union in October 1947, the exclusivity of state subjects remained unchanged.
When the country became independent in 1947, two dominions were established: Dominion of India and Dominion of Pakistan. And there were more than 560 states, Indian states, or princely states as they were called, all over pre-partitioned India. They were given the freedom to join either Pakistan or India through instruments of accession. Almost all the states in India except 3 joined the Indian Union. Junagadh, Jammu and Kashmir and Hyderabad were 3 who took time to take a decision. In Jammu and Kashmir, before the Maharaja of Jammu and Kashmir could take a decision, it was invaded by what were called Kabaili tribal forces in Pakistan. Later on, it was admitted that it was actually the Pakistan army which was in the forefront. They invaded Jammu and Kashmir while Jammu and Kashmir was still to take a decision which side it should go. And then the state of Jammu and Kashmir, the Maharaja, sought India's help and signed an instrument of accession. And the Indian forces repelled the Pakistani forces outside Srinagar. They could not enter Srinagar, and the portion that they had already conquered became Pakistan-occupied Kashmir.
After Jammu and Kashmir's accession, National Conference leader Sheikh Abdullah took over the reins from Maharaja Hari Singh. In 1949, he negotiated Jammu and Kashmir's political relationship with New Delhi that led to the inclusion of Article 370 in the Constitution. Article 370 guarantees special status to Jammu and Kashmir, restricting Union's legislative powers over 3 areas: defence, foreign affairs and communications. In 1952, then Prime Minister Jawaharlal Nehru and Sheikh Abdullah entered the Delhi Agreement, whereby it was agreed that Jammu and Kashmir will have full power over subjects other than those acceded under the instrument of accession. The government of the state and the union also agreed upon the extension of Indian citizenship to all residents of the state, but the state would still be empowered to legislature over the rights of the state subjects, who will now be referred to as permanent residents. It was then that Article 35A was incorporated into the Constitution by an order of then President Rajendra Prasad on the advice of Prime Minister Jawaharlal Nehru and his cabinet.
If, as far as accession is concerned, that is something which is not unique to Jammu and Kashmir, though some people do make it out to be. The instrument of accession which Jammu and Kashmir signed, or the Maharaja signed, is the same instrument of accession which every princely state signed with Government of India. So there's nothing unique about it. It got limited to three counts because, remember, the instrument of accession was signed in October. So this time lag did not allow for the other laws to be extended to Kashmir. Secondly, a promise was made to Jammu and Kashmir that it will be allowed to have its own constitution. So this is the only variance. I mean, while the accession was complete, Jammu Kashmir got the right to have its own constitution, its own flag. I think that is what sets it separate from rest of the country.
Article 35A was brought in by a presidential order in 1954 in order to safeguard the rights and guarantee the unique identity of the people of Jammu and Kashmir. The constitutional provision allowed only the Jammu and Kashmir Assembly to define permanent residents of the state. According to the Jammu and Kashmir Constitution, a permanent resident is defined as a person who was a state subject on the 14th of May 1954 or who has been residing in the state for a period of 10 years and has lawfully acquired immovable property in the state.
While Article 370 protects the state constitution and does not allow any laws which are passed by the parliament in the central list to directly apply to Kashmir, Article 35A just gives protection to the State Subject Act. So this is an essential difference. Secondly, Article 370 came in handy because in 1954, when this was inserted, Article 35A was inserted, because it came through a presidential order, Article 370 was used to insert Article 35A into the Constitution. That's where it was used. Otherwise, these are two separate entities. One protects Kashmir from the extension of central laws directly to Jammu and Kashmir.
Constitutional status of Article 35A has always been debated. Experts believe that Article 35A should have been included in the main part of the Constitution instead of the appendix. Other than this, Article 35A has never been introduced either in the Lok Sabha or in the Upper House, and it was merged into Article 370 through the presidential order. Since it has not been passed by Parliament, it cannot be implemented for more than 6 months.
Article 35A applies only to Jammu and Kashmir, and Article 35A is not an article which has been adopted either by the Constitutional Assembly of India or by any legislative body. Article 35A is actually part of a presidential order which the President of India is authorized to issue under Article 370 of the Constitution. Article 370 concerns the relationship between the state of Jammu and Kashmir and the Union of India.
Article 35A is actually linked with Article 370, but for several years, people living in Jammu and Kashmir have leveled charges of discrimination, claiming that they are being deprived of their basic rights. Bureau Report, Rajya Sabha TV. Jammu and Kashmir is the only state that had its own constitution which provides for an intermediary statutory layer in the state. As per Article 92 of the Jammu and Kashmir Constitution, governor's rule is imposed in the state in case the state government collapses, while in all other states, president's rule is imposed if the state machinery fails. In all states of India except Jammu and Kashmir, the government's failure results in president's rule. President's rule refers to the suspension of state government and imposition of direct central government rule in a state under Article 356 of the Constitution. But Jammu and Kashmir has its own separate constitution that provides for an intermediary statutory layer in the state. As per Article 92 of the Jammu and Kashmir Constitution, governor's rule is imposed in the state for a period of 6 months. The State Assembly remains under suspended animation during this period. The governor may also dissolve the assembly. If it is not possible to restore the state machinery before the expiry of the 6-month period, the provision is extended.
The president's approval is just a mere formality. The governor's rule in J&K is defined by the Constitution of Jammu and Kashmir. And let me correct some people that it's not president's rule in J&K, it is governor's rule, defined by the Jammu Kashmir Constitution. And it's the only period where you can have a 6-month governor's rule.
The state of Jammu and Kashmir has been granted special status under Article 370 of the Constitution. Under the article, the jurisdiction of Parliament and the Union government extends over limited matters with respect to the state of Jammu and Kashmir. It is the only state in India which has its own constitution that was adopted on 17th November 1956 and came into force on 26 January 1957.
Article 35A is part of a presidential order which has been issued under Article 370 of the Constitution. Article 370 of the Constitution concerns relationship between the state of Jammu and Kashmir and the Union of India. While the Constitution categorically accepts that Jammu and Kashmir is an integral part of the Union of India, it has been provided under 370 that only matters regarding defense, communication, foreign affairs, etc., as provided in the instrument of accession, will apply to Jammu and Kashmir, but in other matters, articles of the Constitution or laws of this nation can be applied to Jammu and Kashmir subject to agreement of the Constituent Assembly of Jammu and Kashmir.
Clause 2 of Section 26 of the Jammu and Kashmir Constitution states that the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. Section 46 of the Constitution of Jammu and Kashmir provides that the legislature for the state shall consist of the governor and 2 houses to be known as the Legislative Assembly and the Legislative Council. Section 92 of the Jammu and Kashmir Constitution provides for governor's rule in the state in the event of failure of the constitutional machinery. Governor's rule can be imposed in the state for 6 months. During this period, the governor enjoys additional powers, including the authority to legislate. After the expiry of 6 months, Article 356 will come into force, paving way for President's rule. Bureau Report, Rajya Sabha TV. And that's it from us in today's edition of In Depth. We'll be back same time tomorrow with a focus on another subject. You can also watch our episodes online on YouTube and Twitter and get back to us with your feedback and suggestions. Thanks for your time.